let's get some clarity. And I also will take you at some point to what is happening within the EFCC and Mr. Yaya Bello. And of course, before then, I'll take you, afterwards, I'll take you to the APC and what is happening with their leadership. But let's dissect what this justice sector reform should look like. I'm being joined by a former vice president of the ECOWAS Court of Justice, Professor Nwoke Chijioke, joins us live here in our studio. He's a professor of law. Thank you so much indeed for joining us tonight. When you heard what, for example, the Lord Justice Ariwola, what he said about the state of the Nigerian judiciary, he said the onus is on the judiciary to give justice to the Nigerian people. And he said one thing that struck me. He said the Nigerian people are not getting the kind of justice that they deserve. What is your assessment of that kind of statement coming from the number one man in the bench?
I think his statement settles it all, because the generality of Nigerians actually have lost confidence in the judiciary. First of all, I think the judiciary needs a comprehensive reform in all aspects, in terms of, for example, the issuance of these ex parte orders. And justice is only done when there is fair hearing. But in terms of ex parte orders, only one party is listened to, and everything is determined on the basis of his own, perhaps, depositions. And while we were in the law school, we were told that ex parte orders should be used sparingly only in exceptional situations, in situations of emergency. But the best is to put the other party on notice so that he will be in a position to answer to all the allegations that are contained. Secondly,
sorry, apologies for our viewers, because when lawyers speak about some of these terminologies, it's alien to the minds of those who are non-lawyers. An ex parte for our viewers tonight who are not so familiar with some of these terminology. An ex parte means that if I have a dispute with you, you approach the court to say, look, stop Shehu from going ahead with that action because it will hurt me. And the court says, okay, Shehu, you cannot go ahead until 14 days or 7 days, depending whether it's a state court or a federal court or whatever the nature of the court, the nature of the matter is. So it is an order, an estoppel to say, look, wait until until both of you appear before me. So that is the situation. And there is the concern about the manner in which our courts give this. So the question will be, you collect one ex parte in Jos, you collect one in Kano, you collect another one in Abuja. How come this is happening in our country?
Well, it's really a very great concern for the judiciary especially. In terms of even these courts that give these orders are courts of coordinated jurisdiction. In other words, they have the same powers.
On the same level.
On the same level. They are not,
one is not more superior
than the other. Exactly. And now when there is a conflict, in other words, a court of coordinate jurisdiction issues one order, another one counters it. It brings what I will call confusion and very, very opprobrious in the judiciary. In other words, it leaves the parties the question, which order is to be obeyed? By the virtue of the Latin maxim, omnia presumpta res esse acta. Every conduct by an authority is presumed to be legal, and that all the things that are supposed to be complied with has been complied with. So the two orders are actually binding. But when it comes to questions where there are conflicting orders, it becomes a question of which one will you be in a position to comply with.
But Prof, there is the NJC, which is supposed to be the body to regulate when there is an error. Judges are human beings. They could make error. I could sit in Jos and don't know what my colleague in Abuja is doing. So that mistake might happen. There seems to be a lose in the coordination. The chain of the handshake between the courts are not really there, because most of our courts are not digital enough to know what exactly is happening in their next door. So the NJC also, are they doing the right thing in ensuring That if the courts are making the mistake, to correct them immediately
Of
for the
course,
sake of our society.
Well, the NJC also consists of human beings. And again, is this question of knowledge that you have said. Is it not better to put the other party on notice on a particular motion, an interlocutory motion, where the two parties comes before the court at the same time? And when they do that, there may be no possibility of one of the parties going to another court and institute an action on the same matter if both of them are before a particular
So
court.
it's a legal shenanigans.
Exactly.
That is, that could be stopped by the judges.
Yes, it can be stopped by the judges. Of course, it can be regulated. It can be controlled by the agency by sanctioning, where you sanction judges, even without the knowledge of an existing order. When you sanction judges who have issued these orders, exercising coordinated jurisdiction, then I think it will be perhaps a preventive measure for other judges in subsequent cases not to toe the same path.
There are legal scholars and there are those who I call legal technicians. A lot of the times in the Nigerian judicial system, the legal technicians always have their ways because our legal system is also procedural, not only in terms of the content and the meat of the law itself as it is also the fact that if you understand how the techniques and the procedure works, on how our courts and their procedures and their rules work, you may be able to have an upper hand. So it's also good to have the knowledge of techniques and the knowledge of the exactitude of the law. But the question here is, where do we go? You heard the Senate president saying this. You heard the synchrony from the CJN. If we are to achieve a proper reform of our justice system, where do we begin from, Prof?
I think in the first instance, it should begin with the appointment of judges. Judges these days are appointed arbitrarily. There should be a procedure through which judges, those who are aspiring to be judges. For example, in the ECOWAS system, you see a procedure where the chief justices of the Federation of ECOWAS member states, when ECOWAS advertises for those positions, any person who is interested in being a judge goes through that procedure of making an application. And it is left for those luminaries to select the wheat from the chaff. And there's a competitive interview from the members, from the applicants of member states who are supposed to produce judges. But in Nigeria's situation, it appears more often than not, it is done through the back door. It is not open. It is not transparent.
So it looks like is an appointment for cronies, for
Precisely.
friends, family members.
And that's exactly what is happening now. If your father is a judge today, you're likely to be a judge tomorrow.
Or your husband is
a judge. Or your brother is a governor. And so on and so forth. Or your brother is a Senate president. Or the House of Representatives. When judges who are supposed to be impartial are appointed in this manner, then the fulcrum of justice is destroyed. In fact, the basic thing is that justice is first rooted in confidence. And confidence is destroyed when right-thinking members of society go about thinking that the judge was biased.
Prof, let me get your view. What is happening between the EFCC and Yaya Bello? In your own assessment on the face value, what do you think is going on? Because there has been back and forth. In fact, what we hear now is that Yaya Bello and his team has responded to the EFCC saying, EFCC, you lied. The EFCC chairman came out to say, Mr. Yaya Bello, come and answer to your matter. I've given you opportunity, called you to say, come to my office. The kind of honor that I'm not naturally supposed to give, I've extended to you. But Mr. Yaya Bello and his team said, EFCC, you never invited me. You have lied. You, in fact, laid siege on my home. But on the face value, give us an understanding of what you think is going on.
But all these challenges is because of what I would call media trial. An institution of justice should be in a position, especially when you are the investigator, carry out a discreet investigation. You do not need to involve the media. For example, the EFCC's chairman's interview yesterday was really, really uncalled for. It was uncalled for in the sense that you do not need to accord any privilege to Yaya Bello. The law does not require the according or the giving of privileges to persons who are suspected of having committed an offense. That is one. Secondly, the law necessarily does not need, especially in situations of this nature, in corruption cases, you don't need necessarily to make an arrest. You don't need to bring into custody, because more often than not, in corruption cases, they are determined by documentary evidence. If you make out a prima facie case and you have evidence to make out a prima facie case, why don't you file a case in court and serve the accused person? Why would you, in the first instance, perhaps advertise, publicize? Because that is, in the first instance, unfair hearing.
But this matter started since Mr. Yaya Bello was still in office.
Yes, but he had immunity.
Yeah, so but the question here is, how difficult is it for Mr. Yaya Bello to present himself for questioning, for investigation?
But I again ask a question. Must the police arrest you and put you in custody before you are tried? Especially in situations like this. Must you be arrested, incarcerated? If I am an institution, that's the challenges of our institution. If I have sufficient evidence to try you, I make out a prima facie case.
But you look at the case between EFCC and former Governor Obiano, EFCC versus the former governor of Kwara State, Abu Razak, and you will imagine that this person were invited, called for questioning, and they are walking the street. So what makes Mr. Yaya Bello exclusive or different from the rest?
Well, because it's Yaya Bello and the rest, Abdul Razak and the rest of them. Because even where you are accused, even where you are late to have committed an offense, you still enjoy constitutional protection in terms of your fundamental human rights. And therefore, if you think, and that's why the law says, if any person thinks that his rights are being threatened, not even the rights having been violated, but where they are threatened, he has a right to go to apply to any high court for the enforcement of his fundamental human rights.
See, I mean, it does look. Secondly, if this kind of thing is happening, Prof, the question would be: is Mr. Yaya Bello hiding anything? Why is he running away from the law?
Well, is he really running away? If you think you have a case against a man, charge him to court.
So you have a problem with the manner in which the EFCC is going?
I have a problem with that, exactly.
Is the EFCC doing anything illegal right now?
Well, in the first instance, there is trial by media. Ordinarily, fair hearing includes having been in a position to listen to the other party. Yaya Bello is an ordinary citizen of the Federal Republic of Nigeria, notwithstanding the fact that he has been a former governor. And secondly, do you need an ex parte order of court? I think in the Administration of Criminal Justice Act, you need an ex parte order for arresting a person if you are going to keep him beyond the constitutional provisions of about 48 hours. You cannot incarcerate a person beyond 48 hours before you bring him before.
This is what we saw, which there is a particular notice of withdrawal of appeal, which we understand that the EFCC had put in, signed and processed by the lawyer to the EFCC, Mr. J.S. Okutepa, Senior Advocate of Nigeria. Perhaps that's it on the screen right there. What do you make of this particular process of court? Withdrawal of appeal, pursuant to Order 11, Rule 1 of the Court of Appeal, giving notice that the appellant intends to and do hereby only withdraw appeal against the respondent in the above-mentioned appeal. What do you make of this?
That is the appeal. Which appeal? Is it the appeal with respect to the order given by the Kogi State High Court?
it's a suit on the originating summon. That means he was in connection with what the Kogi State High Court has
yeah. Because my question is
because that was the matter that was appealed anyway.
Should you have appealed against an ex parte order for the enforcement of the fundamental human rights without hearing the substantive interlocutory application?
I mean, you seem to have a lot of problem with the manner in which EFCC went about. I mean, the EFCC chairman came and gave clarity on the manner in which his operation is going. You don't like the manner in which
no, the manner is not. It's inappropriate. He may have the right to do that. But
is it appropriate? Those who obstructed the arrest of Mr. Yaya Bello.
Well, I won't comment on those matters that I don't have foreknowledge of, because in the first instance, it was reported that they stopped the arrest of Yaya Bello. I won't be in a position to speak on that one because I'm not there.
Are you worried about the technicalities of this matter? Because those who believe, who think that in all of this,
I'm worried so much because one, in all cases, tell me how many persons have been convicted by the EFCC adopting the same process. This appears to be a recurring decimal in their operations. This appears to be a recurring decimal. A typical example is that of the former Attorney General of the Federation, Adoke, Bello Adoke.
In your own thinking, how do you think EFCC could have approached this?
In the first instance, I think, let's take, for example, the trial of the former President of the United States of America.
That's Donald Trump.
Perhaps precisely. The Justice Department made their investigation, collected their documents, and went to court. When you make out a prima facie case, what is wrong with filing the charges and serving on the accused, the alleged person that has committed the offense? Why do you go through the rigors of we have done this, we have done that? What of all the other people who were arrested and
because
tried?
The EFCC said, look, we have all of the facts which presented in our summons to the court. And we presented the facts to the court in those documents that Mr. Yaya Bello was paying upfront over $700,000 of school fees and allegedly looting the coffers of the
EFCC.
A poor state like
EFCC.
Those are the statements by the EFCC.
Is not a trial institution. That's the facts they have.
But whatever they said is not.
They should present it to
judicial, is it?
They should present it to the court. Well, it's for the court to determine whether a pending case involving EFCC, and if EFCC as a party comes before the media and began to narrate and present facts, perhaps in the court of the media or the court of public opinion, perhaps to convict before the actual conviction.
I mean, do you, Mr. Yaya Bello, think
I am talking only from the point of view of law. I don't want to go into politics and the rest.
He said it's a
of course, at the end of the day, when you normally take the process our institution, like the EFCC is following, it becomes a persecution, not prosecution.
On a final note, how do you think this can be resolved? In the sake, because it's a corruption matter. And anybody who is in public office, the onus is on them to say, I have served, but if there is anything you have against me, here I am.
Charge him to court.
He's been charged to court.
Fine. Let the trial begin. Because once a matter goes before the court, the FCC has no business in investigating anything.
Professor Nwoke Chijioke is a former vice president of the ECOWAS Court of Justice. Thank you so much. And he's also, of course, a professor of law. Thank you so much indeed for your time tonight. I appreciate it.
Thank you.